Hello, I'm attorney Thomas Burton. I'm an estate planning and asset protection attorney here in Wisconsin. And today's video is about how you can make your own will for free in the state of Wisconsin. So at my office, I help families and individuals put a written plan in place for their assets without the confusion and unanswered questions from trying to do estate planning on their own. However, I understand that some individuals are either unable to afford to work with an attorney or unwilling to pay to work with an attorney. So today I want to create a video that shows you how you can create your own valid will in the state of Wisconsin for free. And if you follow the steps in this video, it's possible you could have your will created in less than an hour. What I'm talking about is the Wisconsin Basic Will found in the Wisconsin statutes. So go to your computer and Google Wisconsin Statute 853.55 and it will bring you to the Wisconsin statutes where you will see the Wisconsin Basic Will form. Now, this Basic Will form was included by the legislature in the Wisconsin statutes, meaning if you use this will form under the statutes, it's presumed valid. So I suggest if you want to go about estate planning on your own, you use this will form because the legislature has said, here's a valid form to use. Instead of trying to use some online service or a document you find online that may or may not be up to date, use the one right in the statutes. I'm going to run through it with you, and my goal is that if you're wanting to do this, you can watch this video and complete the will along as you're watching it. And at the end, you could have a valid will in place. So first of all, I'm going to read a couple of the disclaimers, the big print notice at the top. And they say, notice to person who signs this will. 1. This will does not dispose of property which passes upon your death to any person by operation of law or by contract. For example, the will does not dispose of joint tenancy assets, and it does not normally apply to proceeds of life insurance on your life or your retirement plan benefits. So make sure you read all these notices, but basically it's saying that something like a piece of real estate titled as joint tenants with someone else, the will is not going to override it. That passes according to the title, and that's because it's held as joint tenancy. Similarly, if you have life insurance and you filled out a beneficiary designation, that's a contract between you and the life insurance company, and the life insurance company is going to follow that contract upon your death. So just be clear about the will, what it does and does not do. And if you work with my office, we talk about this, the difference between probate and non-probate assets. But if you're doing this on your own, you need to think through your assets and put them into, I would suggest, into pots. You got the probate and the non-probate. So the ones that pass under the will, meaning they don't have a separate beneficiary designation like a life insurance policy, that's what this is going to govern. So think of things like all your personal property inside the home, your house, real estate, boat, cars, other assets. That's all under the will, unless you opt out some other way through title. Okay, this will is not designed to reduce taxes. Read through that. This will may not work well if you have children by a previous marriage or if you have business property, particularly if the business is unincorporated. Okay, so they're saying be aware if you have children by a previous marriage or an unincorporated business, but in specific an unincorporated business like a sole proprietorship. This isn't designed for complexities. Okay, that's why they call it a basic will. 4th, you cannot change, delete, or add words to the face of this Wisconsin Basic Will. You may revoke this Wisconsin Basic Will, and you may change it by signing a new will. So don't, as we go through it, don't try to add in words in writing, change things. All you can do with this one is revoke it by creating a new one, or change it by signing a new one, okay? Or revoke it by physically destroying it. So again, this is not one size fits all. It's just one option, and you need to think about if your situation works for this. Okay, the witnesses to this will should not be people who may receive property under this will. You should read carefully and follow the witnessing procedure at the end. So in general, anyone you're naming in the will, don't have them be a witness at the end. You should keep this will in your safe deposit box or other safe place. So after you sign it, that's a great idea. You want to keep it in a fireproof or fire resistance place. I recommend a safe in your home. You can also use a safe deposit box. If you use that, make sure your personal representative under the will has access to the box after you die, okay? You got to make sure on that slip with the bank that you give them access so they don't have to open a probate just to get access to the will. You want them to be able to get the will and present it to the probate court. 8, if you marry or divorce after signing this will, you should make and sign a new will. So there's another big change. This will isn't designed to be super flexible. So when you work with my office, I try to plan a place that's flexible. They're not necessarily basic or simple, I tell people, but they're flexible. And that's so that you don't need to change it all the time. My goal is that you can put a plan in place for many years. But this one is very basic. So if you marry or divorce, you better look at it and sign a new one, is what they're saying right here, okay? Finally, this will treats adopted children as if they are birth children. So if you don't want that, then you don't want to use this will. If you have children under 21, you may want to use the Wisconsin Basic Will with Trust or another type of will. So if you have minor children, and that second, the Wisconsin Basic Will with Trust follows this will in the statutes. So look at that if you have children. Finally, if this Wisconsin Basic Will does not fit your needs, you may want to consult with a lawyer. So they're saying right in the statutes, and I do agree with this advice. For the vast majority of people, if you can afford it, consult with a lawyer. And if you can't afford it or think you can afford it, you can save up money till you can afford it. Or I'm giving you this option today to get a basic will in place, then save up the money to meet with the lawyer and get your custom plan put in place as soon as you can. So the other thing I'm thinking is this will is valuable if you're in some situation where you need one quickly and you can have people witness it for you, friends or neighbors with you. So then we get to Article 1 of the Basic Will. Insert your name, it says here. So you want to put your name in there. And this is all printed in so it's legible, so people can read it. Then it says, this is my will and I revoke any prior wills and codicils. And I'm not going to read all of it, okay, but you read it as we go through this. It says personal, recreational, and household properties. I give all my furniture, furnishings, household items to my spouse if living. Otherwise, they go divide equally among my children who survive me. Then, gifts to persons or charities. I make the following gifts to the persons or charities in the cash amount stated in words, dollars, and figures, or the property described. I sign each box used. I write the words not used in the remaining box. So here they put in, this is very different than a will I would prepare where I have everything typed exactly how you want it. But this is designed to do it yourself. So you put in the amount, so $5,000 cash, and then you sign next to it. Or you put in grandma's china set and describe it sufficiently, pink china set, and then sign next to it. Any box you don't use, you write the words not used in the remaining boxes. So you sign next to, you write it in and sign, and then any you don't use, you write not used. So you want to make sure each box has writing in it, either something you used or you wrote not used in the remaining boxes. So again, this basic will is basic, but it's not necessarily simple for you to complete because there's actually more work to it than having a lawyer prepare your will and you just sign at the end. Next, 2.3, all other assets. I adopt only one property disposition clause in this paragraph by writing my signature on the line next to the property disposition clause I wish to adopt. So again, they're putting in multiple clauses. You got to choose the one you want, and then you write your signature on the line for the one you want. I sign on only one line. I write the words not used on the remaining line. If I sign on more than one line or I fail to sign on any line, the property will go under property disposition clause B, and I realize that means the property will be distributed as if I did not make a will in accordance with Chapter 852 of the Wisconsin statutes. So it's saying if you mess this up, then clause B applies, which is basically the Wisconsin intestate statutes. The succession scheme under the statutes is generally to your next closest living relative. But if you mess it up or don't choose or sign on multiple lines, then it goes according to clause B. But clause A, if you're married, you probably want this one. If my spouse, if living, if not living, then to my children and the descendants of any deceased child by right of representation. So I think a lot of people, if married, you're going to want A, or if you're planning to get married. And there's a line there, it's faint on this camera, but that's what they want you to sign by, the one you choose. Just one line there, the one you want. Then we go to Article 3, nomination of personal representative and guardian. And this is key and one of the reasons why it's really good to make your own will. You get to choose your own personal representative, which is the person who would administer your estate after you're gone, and a guardian for your minor children. So here there's 3 lines. First personal representative, second and third. And it says, I nominate the person or institution in the first box to serve as my personal representative. If that person does not serve, then I nominate the others to serve in the order I list them in the other boxes. So write in their name, and I suggest first name, middle initial, last name for an individual. And if it's an institution like a trust company or bank, write in the actual name there. Guardian, if you have children under age 18, you should name at least one guardian, and I agree with that advice, of the child. This is the people who would actually take care of your children and raise them. The legal guardian if something should happen to you. So for anyone with minor children, if you don't have a will in place, I suggest you could do this today and have at least a guardian named instead of leaving it up to the court. Because when someone passes, it often can lead to fights among the family who should be the guardian. So if you know who you want that person to be, name them in your will. And especially in families where the parents may not be married and you share custody, this is also very key to put your wishes down. So you can name the first guardian and the second guardian. Again, write their name. I suggest first name, middle initial, last name. Now, bond. My signature in this box means I request that a bond be set by law for each individual personal representative or guardian named in this will. If I do not sign this box, I request that a bond not be required for any of those persons. So in general, in most of my wills, I waive bond. If you have a very large estate or you don't trust the person you're naming, you might want to have them post bond, but in that instance, I would suggest you not name them as personal representative in the first place. So if you do not sign, you request that a bond not be required. So this decision is up to you, but a lot of people, I don't think you necessarily are going to want to require a bond be posted. So you might just, in this case, don't sign that box if you don't want your personal representative to have to post a bond in order to serve. And bond is amount of money. So then it says, I sign my name, okay, we're right here, to the Wisconsin Basic Will on date at city state. So wait to sign it until you have the 2 disinterested witnesses there with you. And their lines are right here. signature, print name, residence, date, sign, the witnesses. And you can read what they declare. The witnesses declare, I declare that the testator, that's the person making the will, so if you're the person doing it, watching this video, it's you, sign the will in front of me, acknowledge to me the document was his or her will, and or acknowledge to me that the signature above is his or her signature. The testator appears to be of sound mind and not under undue influence. So if you're watching this video and you want to plan this will, you can have this video as reference and pause it in these certain sections as you go through and fill it out, and then just start the video again. So for instance, if you fill out the will and then you need to get the witnesses, pause the video here right before I start talking about the witnesses, and then you can play this part as you do the witnessing part. So again, it's key that the witnesses not be named in the will to receive property under the will. And I generally say a witness should not be related by blood or marriage or receiving property in the will. So the best thing is to choose friends or neighbors who aren't in the will, like your children or spouse or other relatives. So then bring the witnesses over, and you have the line for you to date right in the actual city or, municipality where you're signing it, and the state on the date, wherever you physically are when you're doing it. And it should be in Wisconsin. Generally, I recommend, if you're a Wisconsin resident, try to do it while you're here in Wisconsin. But you fill in the date, city, and state, and then you have the witnesses there, and you sign, and they watch you sign in your physical presence, and then they sign below and sign below, signature, print their name below the signature, and then print their residence address and the date. And why I suggest they sign, I do this on my wills too, and print is so some people's signature you can't really read it. So have them do first, middle, initial, last name as their printed name. And I suggest they sign that way as well. And then, congratulations, if you get yours signed in front of the witnesses and them signed, you have a valid will. So the key to making a valid will is signing it properly in front of the two disinterested witnesses. And that's, when you work with my office, that's part of what we also help you with at the end, getting the signing correct, because you don't want to go through the work of creating the will, because you can see even this basic will involves a fair amount of work, but then make a mistake when signing it and it's not actually valid. So that's why I suggest, if you're using this video as a reference, pause it at the signing part. You can even play this part with your witnesses so they understand, and then go ahead and do it. Now, there is a way you can sign and then acknowledge it in front of the witnesses under the law. I don't want to get into that being confusing today, so I suggest what you do is just literally wait to sign it till the witnesses are right there. So they watch you put the pen on the paper, and then they do it right after you, okay? Then you'll have it all on the same date. The dates will line up. And one other tip I suggest at my office, I have people sign the original documents in blue ink, and then you know that's the original wet signature. Once you've signed your will, keep it in a safe place like we suggested at the beginning. A safe in the home or a safe deposit box. The key is to keep it safe from fire and flood, because if fire destroys an original will, that is the only will, and by law we must have the original to present to the court. So if we're using trust planning at my office, we can make a copy, and there's a little more flexibility under contract and trust law if we lose it, the original trust, to use that copy. But with the will, you really need that original. Closing notes, the Wisconsin Basic Will with Trust that they suggested, if you have minor children, if you want to look at that, that comes next in the statute, but you're going to follow a similar process. So I'm going over the Basic Will, which is going to be applied to most people in many situations, and you can also reference the next one after that in the statute. And again, it's Wisconsin Statute 853.55. So just Google Wisconsin Statute 853.55 and go to the PDF version of the statutes, and you can print that out and use it. So I hope this video has been helpful to you. Part of what I do here at my office is I educate and inform my clients in order to empower them to take control of their own estate planning and put them in the driver's seat. And what I try to do with these videos is give you that same information to help you with your own estate planning. So if this is something that you need to get done, you can do it today. And like I said, you could have it done, watch this video, and have it all done in less than an hour. If you have questions or need help or want assistance with your estate planning, feel free to contact my office. We've helped lots of people just like you, and I'm confident we could help you as well. However, just be aware, if you do contact us for services, we do charge for that type of thing, because when we do that individual custom planning for each client, it takes time and effort, and that's how we make money here at my office. So this video today is totally free. I do it as a service to the public and to try to help you. And again, my goal is that you can go through it and do this on your own if you ever find yourself in that situation. And one last resource I'll mention is, if you're wondering more about your estate planning and whether you need a will or a trust or something like that, I have a free one-page will versus trust guide. It's available on my website. I'll put a link in this video, and you can click the link, enter your email, and that'll get sent to you as well. So I try to provide as much free videos and resources as I can to help you out. And if this has been helpful to you, please consider, give it a like or a comment. And again, you can just follow along on your own. Go back to the beginning, Google the statute, print it out, and then I suggest watching this video as you go through it, and you can have your own valid Wisconsin will prepared in about the time it takes to watch this video. Thanks for watching, and we'll see you next time.